Dear participants, dear friends of the Global Digital Encounters, I am happy to see that we have participants connected from all over the world, and also to know that we have so many participants in academia, in the IP profession, in the legal profession, and among students who will follow the registration we will post at the end, the day after our Global Digital Encounter. This Global Digital Encounter 16th is dedicated to domain names and intellectual property. With the COVID pandemic, and even further to it, the trade and business has largely moved from traditional operations to online operations. The domain name becomes more and more important. More than 20 years ago, mechanisms were put in place, thanks to ICANN, but by WIPO and its member states, to further link the relation between domain names and trademarks and other intellectual property rights, and also to permit, as such, to fight cybersquatting, cybergrabbing, and other phenomena that could alter trust in business. With the current pandemic, the post-pandemic, the digital age is further developing. Many businesses have moved to online, and therefore domain names have gained a new centrality, in particular for their defense and their protection. This is why we have invited exceptional panelists to the current Global Digital Encounter, who will give you a vision from all over the world on how internet domain names may be better defended, better protected, and what should be done in this respect in order to permit business to really get all the advantages of the digital environment. We have with us Caroline Berube, who is from Canada, but lives somewhere between Singapore, mostly, Canada and China. She is a top IP practitioner known throughout Asia and North America, also active in Europe. She teaches at the Bocconi LLM in the law of internet technology, and she is one of the stars of Asia in making IP rights better embedded and enforced. We have with us Professor Malcolm Bain, who is from the University of Barcelona and also develops one of the most tech dynamic legal practices in Spain and in Europe. He's from the UK, but in a way as well also from Spain and France, and develops so many activities in order to ensure the full understanding of intellectual property rights in the digital environment, teaching in many universities, including at Bocconi, at the Alicante University, and in many other places in the world. He is also a big friend of the Global Digital Encounters. We have with us as moderator Professor Joe Secon from the University of Portsmouth, who is the winner of many UK and European prizes for the relation he has constructed between IP and business, IP and technology, IP and all the fields of new areas where he develops his activities. Professor Joe Secon will be the moderator of the current session. As such, he will be the one in charge of running the smooth operations, in addition of being active in also commenting and presenting throughout this session. Last but not the least, I would wish to thank our partners, the partners of Fide and the Transatlantic IP Academy, who have pulled from all over the world to support this pro bono activity and are permitting the IP world to shine, to question itself while shining, and also to see new ways to construct. I would now give the floor to, as director of this Global Digital Encounters jointly with Professor De Santis, whom you just saw present now, I would wish to give the floor to our coordinator, Professor Javier Fernandez-Laschetti from IE, who will also wish to welcome you at this activity. Javier, the floor is yours.
Thank you, Laurent, and thank you, you all, for coming once again to this digital encounter. Today's topic is very, very interesting. I think that the founders of the internet never imagined the problems that they could create to the legal community or to the business community by creating this fantastic, amazing tool as the internet is, and the domain names as a point of identification. From then to now, things have changed. Well, haven't changed so much. I mean, the conflicts are here and will remain. And most of us were involved one way or another in conflicts about domain names, and even Julia Roberts was involved once a time about something like this. And something that is interesting, I would say, is that maybe this is one of the first times where intellectual property and information technology met and created a sort of mixture where we are, and currently drive us to a situation where it's sometimes difficult to differentiate what is IP and what is IT law. And and it's also important to point out that this question of domain names have created I would say, first digital jurisdiction by the enactment of UDRP rules and the administration of means for solution of conflicts through administrators such as WIPO and others. So this is something that has created a big literature, discussions, etc., and it's very fascinating. So I would like to spend more time with this introduction. Thank you for being here. Remember that you belong to a community, so we hope to have your comments, to your questions, etc., and enjoy. And give the floor to Joe. Joe, the floor is yours. Thank you.
Thank you, Javier. And just to reiterate my thanks to Lauren, Manuel, and yourself, Javier. This Global Digital Encounters is absolutely fantastic, and I've been following these avidly from the beginning. And the community that you three pioneers have created is absolutely wonderful. And I know, hopefully, fingers crossed, some of my students at Portsmouth will be enrolling, hopefully, on this webinar today, but certainly subsequent ones. Also, my thanks to Caroline and Malcolm. Although I have some knowledge of domain names, I'm really interested today to find out more about domain names in terms of China, Singapore, and also Malcolm, the European Union. So if we start off with one question, which I think will be insightful for the audience, is could you, and I'll start with Malcolm, could you just talk about sort of the current landscape in terms of how an individual and organisation sort of protects a domain name in the European Union, just to start off with sort of the basic framework?
Okay, well, good morning, and thank you very much, and thank you to the organisers for inviting me to this prestigious encounter these days. So it's great to be here. So quickly, just to kick things off, as you say, domain names registered through registrars and registries on the internet. How to protect them? The basic is through trademark law. So the domain name itself is use of a name, of a sign, and therefore if an entity wishes to protect a domain name or recover a domain name, I think the easiest ways is to ensure that it has the trademark to be able to have a legitimate right to enforce against the registrant. Okay, that's not always the case. Sometimes the domains happen first and the trademark comes afterwards, and so you have a timing problem. But both the law and the UDRP gives preferential rights, let's say, to a trademark holder. And that is, there are other ways of protecting it. So once you have the trademark, or if you have the trademark, you can either start a traditional court case through trademark infringement, because the courts see the use of a domain name is a use in commerce, and therefore one of the prohibited acts or these controlled acts. But as you have already mentioned, through the UDRP, which is the process, the arbitration process set up by ICANN and the WIPO, there's another way to reclaim it with different arguments and different legal bases for obtaining it. And finally, if it's a competitor or someone who's active in the market is using the domain name in any anti-competitive or unfair manner, you could also base a claim on unfair competition. So basically there's three ways of doing this in terms of reclaiming or protecting. There's a much more practical way, which is much cheaper as well. It's just to buy as many domains that protect or that are your trademark as possible. And we can speak about the economics of this later, but basically it costs a minimum 1,500 euros to do a UDRP. With that, you can buy 150 domains basically. So a preventive action, as opposed to protective action, is to buy as many useful domain names around your brand as possible.
That's
back to you.
Yeah, no, thank you, Malcolm. That's a relief, because the last point you made there about buying as many domains as possible is the advice and guidance I give to startups that I engage with here in the UK, just simply because of the costs in terms of trademarks and also the UDRP. And what was sort of interesting there, you talked about unfair competition, and just from a UK perspective, we don't necessarily have that, but what we do have is something called the tort of passing off, where we look at if a third party has, by virtue of using a similar domain name, is borrowing someone else's goodwill and reputation. So sort of there are overlaps there. Caroline, I was just wondering if you could sort of comment on sort of the Chinese and Singapore perspective.
Yeah, sure. Thank you. I also want to say thank you to the organization to have invited me to talk today. And I think it's a really exciting topic. If you think about it, there's like about $4.8 trillion in e-commerce. That is in 2021, or apparently that's what the statistic says. So of course, like, domain name is crucial. And I would say, like, if for me, based in Asia, like, it's a huge market. If you think about the fact that, like, in China, there's 1.3 billion people. A lot of our clients who come to Asia, they really want to tap on the Chinese market. So one of the first questions they have is, like, should we have our own selling platform with a .com or .com.cn or .cn? It's always like the first big question. And to the point at what Malcolm said, like, of course, in the ideal world, they should register their trademark in China and then get their domain. But of course, they get so excited about the potential market that they just do whatever they feel in no specific order. So in China, from a legal perspective, like, you have to register first to be protected. So it's the same for the domain, but also for the trademark. So if you're going to register your domain in China, you have to go to the official channel, which is the China Internet Network Information Center, the CNNIC, which is basically managed by the Ministry of Information Industry, which is the government. As you must expect, like, a lot of these topics are governed by and regulated by the Chinese government, and they really like to keep an oversight of what's happening. So if you go on that platform, like, it's in English and Chinese, which, like, if you think about, and I'm just going to switch off, we talk a bit about technology law and IP. If you go back for the trademark aspect in China, a lot of our clients say, well, I will save money and I will register my trademark myself. They start to go on the website of SIPO in China. First page is in English, but then page 2 that they need to fill up to register their trademark is in Chinese character. So very quickly, the clients or the companies start to, like, they give up because they cannot carry on the process of registration. So for the domain, though, like, the CNNIC is in English and Chinese, so you can register your domain yourself if you want. It is in English, but you have to go through usually like one of the 60 registers which are approved by the CNNIC. Now, you know, like to be able to register a .com.cn or a CNN, unfortunately, you do have to show that you have a business license of a Chinese company. And it's usually valid for 1 year to 5 years for the domain registration. So a lot of our clients that don't have a company yet in China, they're at the beginning of their venture in Asia, so they don't have set up their company yet. So they do need sometimes to use the business license of someone else to say that they want to register the domain. So this brings a bit of intricacy because in fact the domain doesn't really belong to them. It belongs to the company that has provided the business license. So this is a bit of a challenge. So they should really use like, you know, like a company that they trust, that they won't try to take advantage of them after. So this is for China. Singapore is a bit more straightforward. There's no language barrier, as you all know. Very square common law jurisdiction. So you basically just go to the Singapore Network Information Center and then you can register your .com.sg. You can use it, you can register through an agent, but you will have to prove an address. So usually we'll also use the register address, which again, like bring a bit of risk from your perspective, but usually these registered company are reliable and they don't have like the reputation of squatting your domain after. But you still have to go through a third party in some ways to prove your registered address in Singapore.
Yeah, thank you, Caroline. Just one thing I picked up, and please correct me if I'm wrong, but so in China, can individuals register domain names?
If you're not a Chinese, that's a good question. Thank you, Joe. If you're a Chinese individual, you can register .cn. So they really split. If you're a foreign individual like me, for example, yes, or you're Chinese, then you will have challenge in terms of .cn domain.
Okay, well that's interesting because
so the requirement will not be the same.
Yeah, the reason why that sort of struck a chord with me is that one of the issues we face in the UK, and I think Malcolm will probably agree with this, is that cyber squatting in terms of the case law here in the UK, one of the most famous cases was BT versus 1 in a million. I think that was sort of back in the 1990s. And the reason why cyber squatting really became a sort of a common term was that we had so many individuals just literally buying up domain names and then trying to sell them on to what we'd call in inverted commas the legitimate owner. And so it could be, and I mean, I'd be grateful if you have any insights on this, whether the issue of sort of cyber squatting is less prevalent in China because obviously they have a filter in terms of who can actually register the name in the first place. Because here in the UK, as you probably know, and probably in Singapore, literally if the name is available, you can go to any domain name reseller and just purchase the domain.
Yeah, that's a good point. You know, I feel there's a bit discrimination between if you're local and if you're not a local in China. So a company that, you know, like is Chinese can basically register as many domain as they want.
Okay.
And the business license doesn't have necessarily to match the type of activities or what the domain will refer to. So there is a lot of cyber squatting, unfortunately. Right. And I don't know if we can discuss this now, but you know, like of course, there's, then you have to go to you can go to the CNNIC for dispute and show that you have like, you know, like they use with bad faith your domain name, or otherwise you have to go to civil court, which is also like, in fact, there's a new law that came into effect in 2020 specifically about how the Supreme Court should interpret this type of case of cyber squatting, because there was so much gray zone that the new law like was a revised version of how it should be, how a judge should apply and interpret the cyber squatting, the cyber security law.
Can I just chip in there?
Yeah, of course.
It's interesting that because I think whereas .com, .net, these kind of global ones are much more you know, Wild West. I think the CCTLDs, so the country codes, are a little bit more restrictive. Certainly in Spain, for example, in the oranges, you had to have a Spanish trademark to be able to request a Spanish domain name. So it wasn't nationality or business presence, but to actually have a Spanish trademark. But that was seen as too restrictive, and they were kind of losing the battle for space or in internet. So now that's been softened up. You still have to prove, at least in the terms and conditions of registration, a link with Spain. So if you want a .es domain name, so there's some form of domain, and this is very useful, because if you've got third parties who have no link with Spain and are cybersquatting to take advantage of brand name or whatever, on top of the actions I mentioned in terms of trademark action or whatever, you can actually apply directly to the registry, the ethnic registry, and say, look, this registrant has no link with Spain. It's obvious. Please have an administrative action for suspending or removing the mark. So that's another useful way, and I think it's brings some order to the issue of at least the country level names.
Yeah,
I do have a question. So which type of link do they need with Spain?
Oh, that's where the gray area is.
To have a Spanish employee working for them, or how?
No, that's a grey area, of course. It's basically like this question of bad faith in the UDRP and whatever. It's a little bit of grey area, and I think you could probably bring any form of evidence of having either commercial sales in Spain, or having an entity, or having a business affiliation or whatever. But at least it's some screening. And the typical cyber squatter who's just doing pay-per-click or other domain parking is obviously a much more difficult position to prove this type of link.
So you see, if you think about it, I feel from a Chinese perspective, then the fact that they require, like, if the requirement to register if you're a Chinese citizen or Chinese company or less stringent, I feel like at least it's a very clear cut. You're either a Chinese citizen or you're not, which is pretty easy. And you either have a Chinese company or you don't have a Chinese company. But at the same time, I think it brings unfair balance, because like then it's very difficult for a foreign company to tap on the local market and to have their own domain, because they are like the Chinese are one step ahead all the time.
I mean, that's fascinating. I mean, I think one of the issues we can now possibly sort of look at in a bit more detail for the audience is this whole issue of what constitutes infringement. And all three of us have already mentioned this issue of bad faith, as we call it in the EU sort of terminology, and here in the UK. And also, I think in China, there's the concept of sort of malicious intent or unfair competition. So I was wondering if we could start with you, Malcolm, if you could sort of expand upon this concept of bad faith, because on my understanding of the UDRP process, a bad faith or proving bad faith is very essential to securing a positive outcome for a legitimate registrant of a domain name holder.
That's right. Yeah, very much so. And it's something that was cooked up, let me say, when UDRP was first put to the community back in the 1990s. As I think most people know, there are three bases three requirements for claiming back a domain under the UDRP, which is having a legitimate right, the respondent not having a right, and the third one is the respondent having registered and used in bad faith. So there's all sorts of legally things there. So it's registration and use, you need to prove bad faith at registration and for use, which is not so easy. I'll give a couple of examples after that. So, and then the UDRP itself gives us some examples of what bad faith is. And it's mainly, I think there's a general principle, it seems to be, that it's activity that is targeted towards, negatively targeted towards the claimant or right of the claimant. So it could either be monetizing the brand, it could be attracting internet users, it could be baiting and switching schemes to pull them away from the website. It could be renting or offering to sell the domain name back to the claimant, or the holder of the trademark in this case. So, but bad faith is, I think, it suffers from legal uncertainty, as a lot of these generic concepts do. But I think it's on purpose to keep the flexibility of the domain name system, and also actually to enable the other side, a good legitimate defense for people who are using a trademark, but in good faith. Because, for example, the famous case of Walmart sucks and all the criticism websites, where they are using the trademark, the brand name. It's marginally could be considered in commerce, but often not, because it's a question of freedom of speech. And there is a good legitimate basis based on freedom of speech, for example, for registering that domain and using the mark. So and I think over the last 20 years, you know, with the I'd nearly say hundreds of thousands, but tens of thousands of UDRP decisions. I think they've just had the 50,000th birthday, I think, of UPR decisions, and WIPO is a very useful compilation of decisions in like case law, very Anglo-Saxon style case law. There's a much better idea of what bad faith can be. But as the world evolves, you know, and new schemes are invented, obviously this concept has to be adapted to new circumstances.
And that's yeah. Sorry, Malcolm, you're going to say.
I was just saying a final point. I mean, in continental law, and I'm generalizing because obviously I'm English and Spanish qualified. In Spanish law, the concept of good faith actually is an old civil code concept, and in the commercial code to act in good faith. And for example, unfair competition law is based on a premise that you are acting in good faith. So it's something the courts themselves have not had too much difficulty. Although, as I said, it raises lots of different circumstances.
Yeah, and we see that here in the UK as well. So the concept of bad faith, although sort of it's given a different name in different contexts, but for instance in tort law, passing off, etc., we have the concept of bad faith. So it seems quite sensible that the UDRP process has the concept of bad faith, and the case list that WIPO offer in terms of UDRP decisions is obviously very useful as well. So thank you, Malcolm. So can I come to Caroline? So in terms of sort of this bad faith, and you know, we were talking before the start of the seminar today about this whole issue of malicious intent and unfair competition, which you've touched upon before. But I think it'd be really useful for the audience to sort of understand in terms of the Chinese courts when they're looking at determining the registration of a domain name, whether it was carried out with malicious intent. What does that actually mean? Because that term seems quite emotive.
Yeah, no, that's I was trying to compare, like, you know, like while I was reviewing my notes, Singapore would be like the bad faith and China will be the malicious intent. Now, how are they similar? Are they not similar? It's a good question. You know, so how they would see it, first, the burden of proof is on the one that is the plaintiff, right? And the Chinese court are always very tough on the plaintiff to prove that the infringing company has been trying to make illegal profit by registering the domain name before them. So of course now it's a question of proof and it's a question of quantifying the loss. I don't know if anyone know, but I'm just gonna in case, like, you know, like, so the damage that we can get in China are always pretty low. They have increased over the years, but they're still very low. The burden of proving lost sales is not easy. You know, it's not an easy burden, like, you know, especially if you think about the Chinese market, like, you know, like there's so many people, like what about if you sell like a product which is on the mid-size, like, you know, like on the people, like, you know, like who are average income, like, you know, like you can lose so much sales, but how are you going to prove it to a judge in China? The judge it doesn't make the life easy to a plaintiff. Then showing the bad faith or the malicious intent of the infringing company is also not easy. Of course, if the company that registered the domain name, like, you know, like is in competition with our client, then it's a lot easier to say, yeah, of course there was a malicious intent. But if it's a company that has just been trying to register a lot of domain name to make money on the back of other companies, it's a little bit more difficult. So these are basically the two things that you would use. Of course, like, you know, if the company has been registering their trademark before, you know, in China, and then they cannot register the domain name because another company has been registering it, then you start to have to be able to build some evidence, so it make it a bit easier for the plaintiff. So I would say, like, you know, from a Chinese perspective, there's a few laws that will come into place. There'll be the cybersecurity law, there'll be the trademark law, and they will also have the unfair competition law that will come into place when you have legal proceeding against a company that has been cybersquatting your domain name. Yeah. So
I'd say just about in there. Sorry, I'd say that actually there's quite it's in the criminal, if there are criminal activities like phishing, like counterfeit sales of counterfeit. I think we don't even really need to have bad faith because it's much easier to demonstrate if you have the evidence. And in fact, it's going back to the original question: how do you protect your domain? It's actually easier to report this to the police or to whoever is looking at the customs, for example, for imports, and get them to do the action because it's cheaper. To taking my startup advisor hat on, sometimes faster and much more frightening for the registrant. So it's interesting that you bring in cybersecurity and criminal law issues, because I think that's one of the clear cases where protecting and reclaiming a domain is easier, and the stronger those laws are getting, because I think there's been a strengthening of all these cyber security laws. It's going to be easier for people to do so, but that only covers a portion of the market, probably the most dangerous portion. So phishing, and all that, but it does leave us in the commercial side for these questions of bad faith, which are complicated.
Yeah, no, absolutely, and I guess something that is, from my perspective, very typical to China, like you can often start legal proceeding, or let's say like this for IP infringement. Usually, like, we'll have administrative measure, you'll have legal measure, like in civil court, but you will also have criminal measure. So it's part of the landscape of IP in China. So that's why, and usually, like, it's the one that is the more deterring. Like sending, like, nobody wants to go in any jail, but you don't want to be in jail in China. So if you send a letter, a criminal letter, like saying that there'll be criminal sanction to a defendant, like, the impact and the course of action will change very quickly.
I was going to say, we've just to sort of tie this sort of conversation together. So, I mean, we have been looking largely at, well, okay, what happens in China, what happens in Singapore, okay, what happens in Europe and even in the UK. But obviously, as all three of us know, that domain names, by their very nature, have an online international presence. So again, would you sort of be able to comment on, and I'm pretty sure you've dealt with sort of international domain name disputes, what the legal and jurisdictional sort of obstacles are in terms of domain name disputes? Because obviously it would be fantastic if just the disputes were related just to sort of a Chinese domain name within China and obviously within the European Union. But obviously when we're dealing with international brands, for instance, then it's going to be different jurisdictions. And I think that's quite a sort of a complicated puzzle, which I think the audience would love to have an insight into.
Yeah, can I answer that one first? Because we've just done one recently last year, a case with in Latin America targeting Spanish sites, obviously for linguistic and cultural purposes there. So there are two dimensions to this. In terms of procedural difficulties, obviously identifying the registrant is difficult and getting more complicated as they use more and more privacy shield and privacy services. So that's difficult, and maybe it'll be easier in one's own territory, much more difficult abroad. That's one of the issues, and a requirement for bringing any legal action is identification of the other things. One of the advantages of UDRP is that you don't necessarily have to have that. So the other international, I think, scope is that if the registrants are not necessarily known or difficult to identify or approach, at least the registries and the registrars are visible. You know who they are. With the who is, you know who the registry is and all that. So, and they are the key kind of like central element to the DNS and to the whole domain name system. And this is why I think the UDRP actually focuses on registries and registrars. So, for example, in the case we had, the registry's member to an agreement with ICANN that if they don't reveal, don't communicate the name of a potentially infringing registrant, if they have been required to provide the name, the data to be able to initiate a UDRP action, then the registry itself is on the line, which is good news, because it's a way of finding the right information to identify who the dependent is going to be, and even if you do know if it's someone in your market, you may suddenly find it's someone you know, and you can start extrajudicial action by at least contacting them, and not going through an expensive legal process. So huge complications. But this is where I think WIPO came in right in the beginning and sorted out some of this by setting up this centralized system where with ICANN and the registries, who have to act in good faith and comply with their agreements with ICANN. So that does help out.
Yeah, no, fantastic, Malcolm. Caroline, so I'm sure you
Singapore
must have dealt with disputes sort of crossing over China, Singapore, and Canada and elsewhere.
That's a good question. I haven't been working, I'm Canadian, but I haven't worked in Canada for 23 years. But I'll talk more about Asia. It's my second home now.
Yeah.
But yeah, Singapore has not adopted the UDRP, sorry. So it means that, like we would have to go to Singapore court. This, and then like, like there would be available action would be either trademark infringement of passing off, which I think, Joe, you mentioned earlier, as well. And the trademark would have had to be registered in Singapore as well. So this, I guess, would be the challenge for Singapore. And same with China, they have not adopted yet. They're like negotiating, and I think they will be signing, but it's not yet. So they have same, we go to civil court. We can also go to the CNNIC, like to do a claim if we want. And I guess one thing that I do, and it goes back to when I work for a few years in arbitration or litigation, I always try to go where the breaching party is located, because I feel it's usually, if I have a judgment in favor of our clients, it's easier to enforce, and it's easier for our clients to get their money back. So I would say in some case for China, like, enforcement of a foreign judgment is very difficult. So I would definitely make sure that if I want to sue someone, a company that has registered the domain name of my client in bad faith, like I would probably even still go to China to make sure that I can recover, like, some damage, or at least like transfer of domain name. Okay,
no, fantastic. Yeah, another question I'd like to ask, and it was sort of posed to me by one of the startups that comes to sort of my IP clinic at the University of Portsmouth, was about general top-level domain names. Now, it seems to me that we seem to have a kind of like almost like an avalanche of new top-level domain names and other domain names being released. Do either of you have any sort of comments upon that? Does that sort of create more problems in terms of protection and enforcement of these, which obviously I can see Malcolm with a wry smile and sort of a laugh there, but I think it's from the perspective of an individual and organisation looking to register domain names, it does seem, as you were saying, Malcolm, before, like the wild, wild west. Which domain name do I go for? Okay, I've got one now. Okay, for instance, in my circumstances, it would be a .co.uk. But then there's the launch of something, another domain name which is similar. So do we go back to, as you were saying, Malcolm, at the beginning, use the 1,500 euros or so to register as many domain names as possible? I would really like to sort of hear your comments about the continuous introduction of new domain names.
Yeah, it's difficult. It's difficult, and especially as most startups not even aware of the existence of a lot of these new. I mean, we all know about .com, and when EU came in, we all learned about .eu, but you've got .bottles or .coop or whatever you want really happening. I think one saving factor is that a lot of these have their own requirements for registration. For example, .coop. You have to be a cooperative registered in your jurisdiction, so that if you are a cooperative, then you have some basis there to defend yourself. But other ones are not, or do not have such restrictive. Going back to what we were talking about before, the conditions on the registrant. It definitely is part of when I'm advising on protective IP strategy when you're starting up or you're doing a new branding exercise, is to look into these new GTLDs and see if any of them are relevant for your market, and acquire them. I said preventive action actually is so much cheaper and and faster. And then there also is how much money you invest in your own .com or .eu or .es or whatever it is with market awareness. And so these like kind of like infringing sites or sites that would be damaging to your reputation or whatever, they don't come up in the search results, for example. So they're not so damaging in that respect. So sometimes you can just forget them, just let them fall by the wayside, because their own business model may actually cause them to fail in the end.
And that's interesting you say that, Malcolm, because I think, and again, you'll probably be more familiar than I am, but isn't that the approach that Louis Vuitton, the famous fashion brand, has taken? I think they only sell their products through, I think it's the .com, and there are other registrants who've registered the Louis Vuitton domain name. I'm not sure, but that kind of chimed with me, because I think that's one approach. So instead of buying every conceivable domain name, is just to put your sort of marketing budget towards, promoting one of the domain names, and therefore the others by implication will therefore not be seen as genuine. Yeah,
I think, and this is something we can talk about when talking about the future, but I think the whole economics of domain names needs to be revisited from a structural point of view, but from IP strategic advice to clients, and Karen probably has a similar thing. Where is it most efficient to invest the money that you've got? And if you're a startup, the not very much money that you've got, and how much damage does a .cn, or .co.cn domain do to you, as opposed to spending significant resources in trying to get it back, and more with all these SEOs, all these search engine optimization strategies. I think again, also coming back to this question of damage, how do you prove, or how much damage does an obscure site actually do? So I think the economics of it does have to be looked at, not just the legal aspects.
Caroline, do you have any thoughts, comments?
Yeah, I do have a quick comment. For example, for Singapore, I would definitely go for a general one like .com, because it's a small market. But I feel in China, the buyers, especially if I'm thinking about clients who want to tap on the middle class community in China, I feel they're more sensitive if it's a .com.cn. So I feel I would probably, if I was the business owner, like thinking about tapping on that market, I would probably definitely register .cn or .com.cn, just to show that I really embrace the market and I really want to get closer to my customer. But it's really a marketing reason. It's not like a legal reason. It's just like, if I think about it with a business mindset, and like it just in terms, for example, like, if you look at trademark, they also really do adapt to the local market. You think about a brand like Coca-Cola, when they registered their trademark, they did make sure that they had a Chinese trademark of Coca-Cola in Chinese character, and the trademark is similar to like for example, there's a Coca-Cola, like one Co is like mouth and it's a square. So like for example, the big brand who try to tap on the consumer market, they will register like the .com.cn or .cn. But then it brings also like even more issues about like where will it be hosted, where will the website be hosted, and then there's a lot of requirement in China. For example, if your website will be referring to like a selling platform, then you do need to host it in China, and you need to have a special ICP permit. So like it becomes like pretty. There's a lot of intricacy after to that, because then like you need to have special permit from the Chinese government about the content of your domain, like how you're gonna host, etc. So like I feel depending on the market, like maybe like big market, I believe like Indonesia and Thailand would be very similar. They would like people, if you target sell to consumer, would be like TH or ID. I believe that people will feel like comfortable to buy a product from a domain having these.
Yeah, thank you. As we sort of now come towards sort of the end of today's global encounter, I want to sort of focus more on the sort of future. So what we've really focused on now is hopefully we've given a roadmap to our audience in terms of how they deal with domain name disputes. And I think one of the sort of the takeaways that I'll go back with is when I'm talking to sort of startups that I deal with, is possibly if you have the budget, just as buy as many domain names as possible, or if you have an established brand and you've gone beyond the first 3 years of a startup, then look at possibly just focusing on 1 or 2 domain names. But I think what's interesting to me and sort of about domain names is the future viability of them. And why I say that is, if we look at the general trend in terms of the internet and e-commerce, we're moving, I possibly think, and I'd like to hear your views, we're moving away from websites but to web apps, where domain names are not necessarily going to be hugely significant. I don't know. I mean, that's my sort of views. But where do you think domain name sort of infringement proceedings will be in the next few years? And do you see things such as apps on mobile phones taking over the more traditional website? So, for instance, with Amazon, most people, I would argue, use the Amazon app on their mobile phone as opposed to going onto the website, especially sort of young millennials. But I'd really like to hear your views on, in terms of future reform, in terms of domain name disputes, and also where you see sort of e-commerce going, because obviously that has that will have a significant impact on the viability of domain names going forward. Possibly start with you, Malcolm.
I think there are two questions here, and you said it yourself. E-commerce and domain. Where's it going? Domain names. In terms of e-commerce, I think in terms of trademark and where we're positioning this encounter, it puts the app stores in the position of being a registrar in that sense, is that they're going to be hosting an app with a specific brand, and so you're just transferring an action for recovering a domain name to an action to take down an app that's infringing. If we're looking at apps that want to do some form of counterfeit or phishing or whatever, a form of brand passing off or whatever. So and we know how difficult it is to fight with the larger app stores, let's say. But it's true, and I think that things are going that way. But I think most, at least the next 5 years, maybe 10's a bit longer, but I think most of the people I'm working with, my clients, they do both the app and the online website. The technology behind it is often the same, because it's the convergence of different forms of basically platforms. But it does mean that the domain's still there, and that's the main kind of like window into the e-commerce. So I think that's still going to happen. That's still going to be there, and it's important. Okay, yeah. in that sense. In terms of disputes, I think we need to get over some of today's challenges to make this a more fluid and better regulated area of commerce, really, in that sense, or society. I think the EU and other ICANN itself has been looking at the main challenges and how to get over them, because I think one is the huge difference in it cost me €10 to buy a domain name. It cost me 1,500, if not 3,000, if I've got legal fees to recover it. There's an imbalance there which favors infringement in one form or other. Okay, and that needs to be looked at and understood one way. I think another of the difficulties, certainly in the EU, we're having is privacy law, and the WHOIS problem that was about a couple of years ago. It's still there, and the increasing use of privacy services to hide the registrant. Now, obviously, I think many times that's totally in good faith. People don't really want to reveal their contact details, certainly on personal sites. But I think it's an indice of infringing activity is hiding yourself, and making it much easier to get behind that kind of like privacy veil would help, because you sometimes find that the information behind there is perfectly bona fide, and in fact you don't have a claim. But the company that's trying to protect its brand or its reputation, or whatever, does need to know that information. So I think that can be sorted out. So and this has happened in a couple of recent cases. Well, recent, not so recent, is that the fight has been right at the beginning is trying to get the identity of the infringing party or the person who's made a domain name, typo squatter. And once we got past that barrier, it's kind of the whole case has fallen apart. It's been much easier to deal with it because it's been so obvious that there's, we haven't even had to actually start a UDRP to get there. Okay, so I think where we're going in terms of dispute and recovery, I think we need to look at these challenges, these modern challenges. I think the registrars are also being a bit more proactive in screening, in ex ante screening. So there may be some disputes where someone tries to register and the kind of like some screening says no, you can't register, or you have to show me your European, your ID card, electronic ID card, or identification of the registrant to get it. But that's another, I hate to say that artificial intelligence is going to solve all our problems. It's not, but what it may do is provide some tools for registrars and registries to be able to do some ex ante screening and then reduce the amount.
Yeah. Thank you, Malcolm. And what really struck me about what you said was sort of the last comment about the increasing use of artificial intelligence, and hopefully by registries. I mean, as you're probably aware, intellectual property offices have now started using artificial intelligence when it comes to, for instance, sort of patent applications and so on, and screening. And the other thing that really struck me as well, which I tend to overlook, is that kind of complete disconnect between the cost of actually just purchasing a domain name and then the cost of recovering it. And that in itself, I think, possibly needs to be looked at sort of going forward. Before I come to you, Caroline, I'm just conscious that I want to sort of bring the audience in, but unfortunately I can't see the questions, if there are any from the audience, on my screen. So if the organizer,
I can help. I can help you.
Oh, can you? Right, I can't see them, so my apologies there. But possibly, Malcolm, you can pose those.
Yeah, there's a good question from Chris Bockerson saying, should the UDRP have financial damages awarded, both for complainants and respondents?
Should we just go to Caroline for that one, and then we'll come back to you if that's okay. Thank you, Malcolm.
Okay, well, I don't have much to add because I think like you both cover exactly my thought as well about the fact that we should have more true checks on registrants' intention behind. AI will definitely be a good help for that. And I believe in preventive measure to avoid domain dispute. So like registering your domain name first, your trademark. So if you have a case, you have element and evidence that you can easily use. And of course, if we can have a way that dispute can be more in a uniform process, like throughout the world, it would definitely be easier if all countries can adopt UDRP. Of course, this would definitely be helpful, including Asia.
Yeah, thank you, Malcolm. You were going to comment?
Yeah, I'd very much support what Caroline's saying. Is that the world is global. We need to think global, even if we act locally, and having a framework. That's, I mean, I remember going back in the 1990s, we had this big debate of should this be law, should this be soft law, and it ended up being soft law, or at least not even soft law. It's but it does mean that if we want a global form of self-regulation, that all countries or the larger entities should get involved. And going back to the question of the economics and this question of should we have financial damages, I think it's a good point. I mean, we get financial damages if we make a court claim, if we win, and it is balancing this question of risk. So there's a very low risk now for cyber squatters, typo squatters, to buy hundreds of domains. If they suddenly find that if they can be identified, that they may have to pay, at least the arbitrator's fees for if they lose a claim, I think that increases the risk profile for negative activities, which means which balances. It's an element to balance this. What we're seeing is the economic risk. So I think that would be a good thing. Okay, it does raise the issue of what happens with all these UDRPs, which are a little bit kind of like, is there bad faith? Is there not bad faith? And again, it may put the arbitrator or whoever in this kind of like typical situation of a judge, where in fact there's no order for costs because it wasn't so clear that there's been a breach or not. So I think it's a good idea, but may have its own complications.
Yeah. So I mean, and then if there are any other sort of questions on from the audience, if you could just indicate those, then I'll pose them to you. But that's quite interesting because obviously with the UDRP at the moment, on my understanding, there are no damages as such. It's just basically either the name is returned, or I think under the URS the name is just simply the name is suspended from use altogether until the period of registration completes. So do you think that sort of damages would be quite, or some sort of financial compensation would be appropriate? Caroline?
Bit of a tough one. Yeah. Caroline, I'll send that one over to you.
Yeah, I do believe it should be like they should get financial compensation. But again, it depends. Like, you know, like in China, like if I think about people who have been trying to register the domain and they don't have much money. They're hoping to make money. So even if I sue them and I try to get damage, they won't have any financial. They won't have the assets to give money back to a client.
But it's not the actual damage, which is interesting. It's a threat of having to pay more than just the 10 euros for buying or $10 or whatever it is. So you know, I think people when they're doing these activities, they do take a risk approach and they do balance, you know, risks against benefits, and just having the slightly bigger hammer of potential damage award against you does balance out a little bit more in favor of the legitimate brand holder.
Yeah, and I would say, like, you know, in China, like people, like clients wouldn't want to go to Chinese court for this. They would just think, like, you know, it's too much money. Like I have a client, like, you know, they bought like their domain name for 350,000 euro, you know, to get it back. You know, because they just thought, like, you know what, we don't want any headache, we don't want to spend more money, we don't want to spend more time, we don't have the human resources to build the case to prove the loss that we incurred, so they just gave up, right? But this one was crazy. Like, you know, like I keep telling them that this is way too much money. This is gonna, like, it's gonna also create a precedent for Chinese people to do it. Yeah. Because then, like, you know, then, like, you know, the world is small. Even if it's a lot of people in China, people will start to talk, and wow, we could get this amount of money for, like, you know, like registering it for a company that we will resell the domain. Yeah. I just feel it's creating a bad precedent as well.
Yeah. I think we've possibly just got time for one more question, I think, and then kind of our hour is up.
Yes, we have a question. Well, we have a hand raised, so I'm going to allow Andrea to turn on her camera and microphone and address the panel if she wishes.
So, okay. I hope you can hear me.
Yes.
I'm sorry, I'm in the classroom, so I have to put my mask on. I hope you will understand me.
Yes, Andrea, no problem.
Okay, the question that is constantly running through my mind the whole session was when Mr. Bain, when you were telling us that once I want to register a domain, I should start with getting a trademark. As far as I know, it's not allowed to use your family name. And then I thought about all these small companies just using their family name, because in the first place they were just local. And now in the globalized world, and of course, post-pandemic situation, they try to expand. They have built a reputation on their family name. They can't get a trademark, and once they want to register a domain name for a website using the family name, the reputation, they can't get it, or it's difficult. there was a case in Germany where someone selling cars. He was quite renowned in the local area, so he got a domain name with his family name and a car selling, or in German Autohaus Turan, the domain. And then VW named one of their cars Turan, and they also wanted to get register a domain name. And in the end, the guy who used his family name, which happened to be Turan, he just gave up. I mean, it wasn't bad faith. He just registered his Autohaus, and what would you advise to like, you have a reputation built on your family name, or you have, and then there's a big company coming after you?
Malcolm?
Yeah, I think this is very jurisdiction specific because, for example, in Spain, there's no prohibition against registering your surname. What you can't do is register someone else's surname as a family name, as a trademark. But if you do, and there are very famous companies, and especially wineries, for example, set up and have branded with the name of the family owner, whatever. So I think this seems to be specific to some jurisdictions. The trouble is then there's also the trademark law here says that you can't stop someone else using their own family name. So even if I have registered Bain as a brand, which I can't because there's a very famous consulting company with the same surname, but even if I did, I couldn't stop other people with the surname Bain, operating in commerce under their own surname. So it's a difficult area, I said registering the mark a mark is a preventive or protective action. You don't necessarily need to register to have the domain name. And as we said, there are other ways of increasing the brand value of a domain name of your surname, through different marketing activities, and as you say, the reputation of the company, even global. So I think that would need to be looked at a little bit more on a case-by-case basis, because certainly here we could register. The courts then may say no, it lacks distinctivity because there are lots of Velasco's or there are lots of Rodriguez, and therefore it doesn't gain any specific distinctivity to be able to be registered. So but that's another argument in trademark terms. Okay.
Okay. I think that's our time for today. So I'd just like to say thank you very much, Caroline. Thank you very much, Malcolm. I gained a lot of insights myself there, particularly in relation to China. So I'd like to sort of hand back to Laura and Manuel. Thank you.
Morning, good evening, and good afternoon, everybody. I have to confess that I'm obsessed with this topic. And my obsession started many years ago when I had the challenge to meet, I think it was in the previous millennium, when I had the chance to meet an extraordinary person called Eugenio Triana. He regrettably left us already 2 years ago, but Eugenio Triana was one of the 9 persons who started ICANN in 1999 as a governor. And then with him, I could follow while working at the European Commission, and then while working at the European Patent Office, I could follow very closely how this fascinating invention, I should say, of the domain name system was created, and how it developed so rapidly. So today I have had the pleasure to enjoy a great and profound discussion full of very, very valuable reflections on an issue which you have to understand is quite complex and controversial still today. But an issue I should also add that it is so there to our common future, yeah, and so there to all of us. I have to confess here that this morning, very early at 5 o'clock in the morning, I bought a domain name who had expired yesterday. Yeah. So this is something we human beings we do oftenly. Yeah. As it happened with previous encounters, we do have now to review the recording to learn more. This has been extremely intense. We should read the report also. We should reflect also on the questions which came over. So thanks to all of you, to all those who asked questions, and I assure every single question will be brought on board. Thanks overall to our speakers. They are Caroline and they are Malcolm. Congratulations to Joey. Joey, you have the dirty business, let's say, and you conducted very well in a magnificent way this encounter. 1 hour has passed so quickly, yeah. And when you will record it, you will watch the recording, you will see so many questions have come on the table, and this is a very fruitful tool later on for all our students and all our professionals. So overall, many thanks to all of you, all the persons who have been connecting today. We understand this is not a friendly time for America, 11 o'clock set, but this time we try to move a little bit more towards Asia. Yeah? The attendants are the protagonists of this growing encounters community. So as always, I'd like to highlight the presence of our students from so many different countries. And I would like also to thank very especially to our encounter support team, who is a group very active, who prepares the references and the report of the encounters. Each encounter is a world by itself, but I would like to highlight again and again that all together form what I should say a splendid source of knowledge. There are hundreds of people who either follow the encounter on the spot or later on watch the recordings of all the different encounters, read the references, read the reports, read the questions and the answers. And we are very grateful to all of you. And we appreciate whatever advice, whatever criticism, whatever suggestion you could provide to us. But this is not the end. Our 17th encounter comes next, 25th December 2021, with another topic as complex and as fascinating as this one: standard essential patents. Where do we go? Yeah, how this extraordinary topic has become one of the very top on the world of patents, and this is only the beginning. As always, we will enjoy moderators and speakers coming from all over the world, which will approach the matter also from the legal, from the economic, and from the engineer perspective. So with your permission, Laurent, let me close this encounter by thanking very warmly all of you, by encouraging you to read the report, to watch again the discussion, and to continue cooperating with the encounters. Take care. And come in only 1 month. Yeah, do count on all of you for the next encounter, November 25th, 2021. Thanks for being with us today. Enjoy the day. Bye-bye. Thank you.
Thank you very much. Bye-bye.
Thank you very much. Thank you.